You are now tuned into the Black Law Students Association of Canada's YouTube.
Without further ado, I would like to now cede the floor to our Honorable Justices of the Diversity High Court of Canada, Justice Ha-Redai, Justice Lansky, and Justice Hanif.
Morning. So unless there are any preliminary matters, I assume there are not. Appellant, who's proceeding first is Mr. Labib. Is that how you pronounce your name?
Yes.
Okay. Proceed.
Good evening, Justices. My name is Anthony Labib. I'm here today with my co-counsel, Luke Reedy, representing the appellant in this matter, Mr. Williams, a Black Canadian. Before delving into the issues of this appeal, it's important to recognize that this case affects the lives of real individuals. A 55-year-old Black Canadian and father of two who passed away from COVID because he was discharged from the hospital far too early. When his children tried to resuscitate him, it was too late. A 28-year-old Black woman with hypertension who is currently on a ventilator after COVID spread its way through her community housing complex, killing her father just weeks ago. And this is just a fraction of the thousands of Black lives lost. Justices, COVID has exposed deep vulnerabilities in this country, exacerbating the inequalities in Canadian society. For every white individual who is infected or dies due to COVID, there are 2 to 4 Black Canadians who are infected or lose their life. And this is despite the fact that Black Canadians make up a significantly smaller proportion of the population. The disproportionate effects can no longer be ignored. As it now stands, Black Canadians are part of an aggregated sum to the federal government, and their experiences are equated to those of their privileged white counterparts. The minister is now implementing a one-size-fits-all approach to combating the pandemic, overlooking the disparities Black Canadians face. Justices, if we cannot see the problem, we cannot fix it. And this is why race-based data is essential. This case is not just about saving Black lives amidst the pandemic, but about preventing the government from placing a veil on systemic issues that they have had a role in facilitating. Accordingly, the appellant submits that the minister's ill-informed health measures infringe Mr. Williams' Section 7 and 15 charter rights. You will hear submissions on 4 issues which align with our factum. I will first address issues A and B from a theoretical perspective, demonstrating that Section 15 is violated as the one-size-fits-all approach discriminates against Black Canadians. My colleague will address issues C and D, establishing that Section 7 is violated as Black Canadians face increased risk of death, their personal choices are limited, and their autonomy is restricted. And he will also address Section 1. I will now begin with issue A. Section 15 should require action to challenge structural racism. This begins at paragraph 9 of the appellant's factum. Section 15 is designed to protect groups who suffer social and political disadvantage. It is rooted in awareness that certain groups have been discriminated against. If state conduct widens the gap between a disadvantaged group and the rest of society, then it is discriminatory. Justices, the one-size-fits-all approach both perpetuates the current discriminatory status quo and widens the gap between Black Canadians and the rest of society, justifying government action as it is unconstitutional to do so. And to understand how, we must take a historical perspective. You may find this argument at paragraph 11 of the appellant's factum. Racism is deeply entrenched in Canadian institutions, governing bodies, and practices, and it still manifests to this day in a way that is normalized or rendered invisible. This has resulted in the Black community facing inequities in education, employment, income, housing, and discrimination through microaggressions and more. And these disparities intersect. Their complex interplay is proven to lead to hypertension, asthma, obesity, substance abuse, diabetes, mental health issues, and more, which is evidenced at paragraph 10 and 11 of our factum for your notes.
Counsel, isn't it what you're saying then that it's not race that necessarily makes these Canadians more susceptible to the virus? It's these comorbidities that you're describing. Isn't that a different argument?
Respectfully, it is the comorbidities that have been facilitated by the government. So, rooted historically, the government has once treated Black Canadians as chattels and property. They were excluded from our institutions and education and employment positions. And in turn, and intergenerationally, this has all resulted for constant discrimination and microaggressions, which have resulted in these inequities I have just discussed, which COVID then exacerbates with deadly effects.
Okay, so counsel, I'm trying to understand the issue before the court, because my understanding of this appeal was that it was on the basis of collection of race-based data, not dealing with the entirety of anti-Black racism throughout the history of Canada, even prior to Confederation, right? Those are distinct issues, right? So what is the issue before the court today?
The issue is that omitting race-based data leads to a one-size-fits-all approach that exacerbates the inequalities this government has facilitated. So the omission of race-based data is the issue before this court today, and it widens the gap between Black Canadians and the rest of society, which is discriminatory. The minister overlooks these inequalities in the one-size-fits-all approach. And the minister's stated purpose is to maintain and improve the health of all Canadians. Accordingly, the minister is required to understand that certain Canadians may need different measures and approaches to be in the same good health she is required to strive towards. And this is especially true given the hallmark Section 15 decision of Andrews and Law Society, which states, things that are unalike should be treated unalike in proportion to their unalikeness. And the one-size-fits-all approach, which assumes all Canadians have the same likeness and privileges, is the unconstitutional widening of the gap. The minister has good intentions, but the gap is widened as the respondent is acting contrary to the purpose of her position by putting forth an approach which does not factor in the unalikeness of Black Canadians. This denies Black Canadians from effective health measures to address the growing deadly effects of the pandemic. Vaccines are delayed and far from public distribution. ICU capacity is full, and we are now in the era of triaging, and deadlier variants of the virus are just now beginning their circulation. The pandemic is far from over.
Counsel, some of these, I guess, impacts we've seen, or worsening of the impacts we've seen of COVID that you just mentioned, those apply to every Canadian, not just Black Canadians. So what in particular are you trying to get at through these measures?
They do apply to all Canadians, but towards Black Canadians, they are more substantial and they have a more severe impact as opposed to other Canadians because of the systemic inequities that Black Canadians face that has resulted in underlying conditions that COVID then exacerbates. And the widening of the gap continues as conditions for the virus to persist and grow amongst Black Canadians are generated by the minister's omission of race-based data, as the one-size-fits-all approach does not address disparate effects, which the government is constitutionally required to do to provide equality.
If I may, your primary complaint appears to be it's a one-size-fits-all approach. But more specifically, how do you say race-based statistics would make a difference? Would it be in treatment? Would it be in testing? Would it be, in what way do you say it would or could make a difference?
If we collect race-based data, we can close in on the gap of inequities. The data would be used to understand how Black Canadians respond to virus patterns and the new variants of COVID. It would show us what environmental factors increase risk. And it would be used to understand how they respond to treatments such as ventilators and the vaccine. And it would allow us to effectively use and distribute these types of treatments, making our use of resources more efficient. And this can identify causal factors and allow for successful interventions as they may vary across race.
You're suggesting that the interventions themselves may vary across race. So I think that's speculative. It's not on the record anywhere. But what I wanted to ask you was, do you agree with the first statement that was made at the Supreme Court by Justice Brown, where he says the COVID-19 pandemic is an exceptional circumstance warranting an exceptional judicial response? Would you agree with that it is something different than anything we've seen before?
Yes.
Okay, and then part of that exceptional nature is that there's not much time here to sort of deliberate and make philosophical decisions, if you will, and balance various things, right? I mean, these are that there's a pressing, very, very pressing need here for the government to act in this context, right?
Correct.
So why should the courts be involved in these very, very unique and pressing situation and circumstances that our country is facing?
Firstly, the data would be collected and used immediately, but race-based data goes beyond COVID and its urgency. As mentioned, there's new variants of the virus popping up that are here to stay, and data could allow us to understand how racialized communities respond to these variants, which are just beginning. And we must remember that the pandemic and these variants are far from over, and data is needed for the long haul. And further, the treatments used in COVID are used for all types of treatments and conditions. And as the data can allow us to understand how Black Canadians respond to these treatments, the data is good for the quality of care of Black Canadians in general. And we cannot lose sight of the bigger picture of why we need race-based data. It can disrupt systemic racism by holding institutions and the government accountable, which can both reinforce the trust of the Black community in healthcare and promote their accessibility. And with that said, any potential time length of a benefit coming from this data does not negate the constitutional protection that is required under Section 15. The data can close in on the gap as it would be used to hold the government accountable for the effectiveness of their response towards all communities. We would be able to monitor the qualities.
Based on your previous responses, it sounds like that accountability might come after the fact. This would be something that would come up maybe years later, perhaps in litigation against the government, but it's not really going to save any lives here while we're actually implementing any measures, is it?
It would be used to hold the government accountable from the outset, as when practitioners and institutions know they are being scrutinized for their conduct, they will take steps required to act in a more appropriate manner.
So I get that part of the argument. I mean, it can be perhaps a good idea. Where I'm still not following is how it becomes a constitutional obligation on the state to do this.
As provided in Eldridge, it is discriminatory for a disadvantaged group, like Black Canadians, to not benefit equally from government measures offered to everyone.
Well, Eldridge involved someone with hearing loss, right? And there's a service being provided, and because of that service, or because of that person's disability, they're unable to receive the service. How does that apply here? Black Canadians are still able to get the vaccine. They're still able to get treatment in hospitals. They're not being denied any service. It's a very different type of argument or claim that's being made before the court here, isn't it?
Respectfully, we will have to disagree, and that is because Black Canadians do experience the same inaccess that deaf persons in Eldridge had at the point of access to healthcare. At paragraph 12 of the Appellants Factum, you may see that Black Canadians experience 40% worse healthcare in our institutions, and doctors systematically rate their complaints as less. They see them as dishonest, and they spend less time with them. So even though Black Canadians can get to access, the treatment isn't as sufficient as it is to their privileged white counterparts.
So counsel, here's where we're getting to the crux of your argument, which I think has come up before, right? So I read the factum, but in your factum, the very last sentence there talks about linguistic and cultural competency. It talks about, in the second last paragraph, the low income rates. And so, as you mentioned, these issues are intersectional in nature.
Yes.
And so it's not just going to be race-based data that we're going to have to collect. We're going to have to collect a lot of other data as well, right? And that's where I think part of the challenge is here. Why specifically data related to Black Canadians and not other Canadians? What makes this a constitutional obligation?
And it is this intersection with other variables that makes it most effective. And we'd be able to see how it interacts with all of them. But what makes it so effective is that the other forms of data where it would be able to show its most benefit are already collected. It's already collected in census data, and it's already collected at the point of testing. So race-based data would complement all these other different variables. And with race as the main factor, we could understand how it connects with everything else. And in real time, we could see how race interacts with certain different types of treatments and how the doctors act towards them. And it would be docked down, and we could see how their experience translates ultimately in healthcare. And this can illuminate the disparities. And it's not just the Black Canadians in particular. We are advocating for all race-based data. This appeal is, of course, for Mr. Williams, who's a Black Canadian. But what we are advocating here for is to disrupt systemic racism and collect race-based data as a benefit to all racialized communities.
The fundamental problem that I'm having, though, is what is the basis for saying that this race-based statistical data, the absence of it, has an adverse impact? I mean, yes, if you accept that there are health disadvantages for Black persons for various reasons, how would this race-based data make a difference such that it's an imperiling of the life, liberty, security of the person? I know you're making the 15 argument, but how would it be a disadvantage? What's the evidentiary foundation for that? I mean, surely we need some kind of evidence if you're going to say there's a potential risk here, there's a disadvantage here. What is it?
The disadvantage here is that currently the government is putting forth resources and measures and hoping they fall into the right hands of those who need it the most. We can directly put these efforts and these intervention efforts in the hands of those who need it, rather than just using a one-size-fits-all approach that just hopes it falls into those who need it. And frankly, many Canadians do not need these measures. And there are certain communities who have these disproportionate effects where if we allocate our efforts, we can alleviate a lot of the impact of COVID. Simply put, we need to focus on who is under the curve rather than just simply flatten it. And if I may provide some examples, because in Ontario, we have already seen that race-based data can save lives. For example, once Cancer Care Ontario was able to show that Black women were not being screened for cancers, they were able to deploy evidence-based strategies to decrease disparities. And further, documentation of high rates of HIV among Black individuals and Hispanics has helped stimulate the development of programs that target minority groups at high risk.
Councillor, I'm going to stop there again because yes, I'm familiar with all of these interventions. I can see how perhaps it's a good idea. What makes it a constitutionally required idea?
In the context of Section 15, the Supreme Court of Canada has provided that government practices cannot be maintained if they freeze the status quo of discriminatory practices. And this can be found at paragraph 15 of the Appellants Factum. Without race-based data, we allow systemic narratives to persist, we allow COVID to exacerbate inequalities, and we tolerate the institutionally embedded racism that this government has fostered. And this perpetuates the discriminatory status quo, which is unconstitutional. And inaction accepts inequality. And if Canada is constitutionally committed to substantive equality, it should not be a daunting task to address these issues.
Okay, but again, in constitutional litigation, you have an evidentiary burden. The court cannot adjudicate upon a case without having an evidentiary foundation to say there has been a charter violation. Surely there must be evidence available from which inferences can be drawn here that COVID-19 treatment or impact would be different based on these statistics. And as I understand it, there are statistics in the United States. I mean, are there any potential inferences that can be drawn from the race-based statistics they have in the United States that could be used to draw inferences here in Canada?
In the US, race-based data has actually prompted the development of a patient navigator program in which culturally and language appropriate individuals with special training are matched with patients at risk to educate them about prevention measures for COVID and guide them through the treatment process. So there actually is measures that have been done with race-based data. And with that said, we cannot know exactly what will happen without the data. So in the absence of data, it's hard to clearly see the effects of what would happen with the data, but we would never know the result unless we do it. And that's where we need the federal government to step down, to step in, to take a uniform, consistent, and comprehensive effort to strive leadership across Canada so that we can tackle this systemic issue. And ultimately, we must stop pushing Black Canadians down the list of our priorities. It's time to act, and the time is now.
So I'm still stuck. I'm going back to your paragraph 26, where you cite the CAP test, right? Part 1 and part 2. Is the distinction discriminatory? And so what we're really talking about here isn't that the government is making a distinction. It's that they're not making a distinction in terms of the collection of race-based data. Isn't that what's actually going on here? They're not treating Black Canadians differently than any other Canadians.
That's correct.
When it comes to the collection of race-based data. It's a separate question to talk about disparities in the healthcare system and how Black Canadians are treated within the healthcare system. That is indeed separate from the collection of data, right? So how does the CAP test apply here?
The Section 15 claim of Mr. Williams, it is one of adverse effects and indirect discrimination. And if I might direct the court to paragraphs 23 and 24 of our Factum. So the claim of Mr. Williams was actually recognized by the Supreme Court and End User Law Society as a type of discrimination which considers the unintended side effects of the government conduct. So, and as the Supreme Court has stated, it is the failure to take into account the adverse effects of general state decisions that can result in a Section 15 violation. And despite the minister's best intentions, discrimination can occur through the respondent failing to notice the impact of her decision, and that is what is required here. There is no actual law that is required. Section 15 violation could be found by any state conduct, and it is not just laws. I will now go more into depth into issue B of our argument, shifting to put in the inequities I've discussed at this point within the Section 15 analysis. Step 1 of the test asks if the law creates a distinction based on an enumerated ground. And as established, a distinction is created as first, the minister's omission of race-based data leads to a one-size-fits-all approach, which ignores the experience of Black Canadians, leading to increased infection and death, which is disproportionate to their race. And to remind you, mentioned earlier in our submissions, things that are unalike should be treated unalike in proportion to their unalikeness. And this is what is required of the minister's position, which makes that distinction. She must recognize that the lived experiences of Black Canadians and their likeness is different than that of their privileged white counterparts. It is equivalent to the All Lives Matter movement to assume that they have the same benefits as other Canadians. And second, the minister's omission fosters the persistence and growth of health inequities that Black Canadians face by veiling systemic racism. I will now move on to step 2 of the test, beginning at paragraph 29 of our Factum. Step 2 asks if the distinction is discriminatory. I will work through 3 factors here, provided in the decision of law, beginning with pre-existing disadvantage. The Supreme Court in law provides that one of the most compelling factors is the impact of the government's conduct on groups who face pre-existing disadvantages.
Okay, so counsel, I'm going to pause you there because I want to ask about what the government conduct is here. And you've actually cited, I think, a relevant authority there on footnote 56. So Sharma, at paragraph 214, it refers to, and in fact, it's in the context of the previous paragraph 213, where it says the wrong that is committed by the legislative decision makers in indirect discrimination. In other words, the legislature is passing a law. That law has an unintended effect. That's not what we're facing here, right? You're saying, in fact, they need to make a law, and that's why I anticipate we're going to hear arguments about positive rights or the lack thereof. So how does Sharma and these passages that you've cited in your own Factum apply to this case?
The minister's duty is delegated by the relevant authorities, and the approach she puts forth and the policy she puts forth to combat this pandemic derive from law, and any government conduct here applies. So the fact that the one-size-fits-all approach misses the scope of Black Canadians is in line with Sharma, as is delegated by law, and the conduct here is the ill-informed health measures that miss Black Canadians and the disparities they face. Continuing on with the 3 factors of the test, of course, Black Canadians have faced pre-existing disadvantages, and as established, this is rooted historically and lasts until today. And the next factor looks at the correspondence between the claim and the circumstances of the claimant. And discrimination is established here by demonstrating that the government fails to take into account a claimant's actual situation. And as discussed, the one-size-fits-all approach fails to take into account the different lived experiences of Black Canadians and what they face. And the minister also fails to recognize that the current approach allows COVID to intensify the inequities Black Canadians face by veiling structural racism. And lastly, I will cover the 3rd factor, which looked at the nature and scope of the interests affected. This is at paragraph 40 of the Appellants Factum. And the nature and scope of the interests affected here is threefold. Implementing health measures on aggregate data leads to an ineffective pandemic response. It fuels and reinforces systemic racism, and it allows COVID to aggravate the health inequities that Black Canadians face, leading to the disproportionate effects. And I noticed that my time is running up. Before the court's notes, I would like to direct you to paragraph 36 to 38 of the Factum, which look at Eldridge. And clearly, Eldridge is persuasive for our purposes, and we spoke about it earlier, Justice Haredai, and with how Eldridge has also compelled similar action where deaf persons didn't have similar access to government services, the proposition from Eldridge, which should hold weight in our submissions, is that it is discriminatory for a disadvantaged group to not benefit equally from a government service offered to everyone. And once the government offers a service to the public, it is obliged to do so on a non-discriminatory basis. In conclusion, omitted race-based data accepts the system of oppression going unaddressed, a system which continuously marginalizes the Black community generation after generation, allowing Black communities to increasingly fall victim to COVID, contrary to the minister's stated purpose. This violates Section 15, and the test should lead to a finding of discrimination, as the one-size-fits-all approach discriminates against Black Canadians. My co-counsel, Luke Reedy, will now address issues C and D, barring any further questions.
I'm going to try one more time here. You cite, let me just get the reference so that I'm not confusing here. In footnote 70, tapetat, okay, at paragraph 20. And in that case, there's a similar issue where the court is describing the second part of this analysis that focuses on an arbitrary disadvantage where an impugned law fails to respond to the actual capacities and needs of members of a group. Where is the impugned law? I think I'm still stuck on that point. It's not just delegated authority, it's impugned law based on my reading here.
Respectfully, we do not agree that it can only be an impugned law. And the authorities at paragraphs 23 and 24 of our Factum, we believe suffice to demonstrate that, simply put, the government cannot be a further source of inequality. And the Supreme Court and Quebec Attorney General stated clearly that any conduct can be discriminatory, and it is not just laws. So our submission is within the context that with the delegated authority, any measures the government puts forth should not be discriminatory, and it does not apply to any particular impugned measures specifically. The claim here is one of the adverse effects and indirect discrimination that doesn't take into account the experience of Black Canadians. Barring any further questions, my co-counsel Luke Reedy can continue on with issues C and D.
Seem to be any questions. Proceed, Mr. Is it Reedy?
Yes, that's correct.
Proceed, please.
Good evening, Justices. My name is Luke Reedy, and I'll be continuing submissions on behalf of the appellant, Mr. Williams. I'll be making 3 submissions to the court today. The first, that Mr. Williams' claim does not impose a positive obligation on the minister. The second, that the minister's failure infringes Mr. Williams' Section 7 rights, and that the infringements to Mr. Williams' Section 7 and Section 15 rights cannot be saved by Section 1 of the Charter. Justices, our submissions regarding positive obligations can be found starting at paragraph 44. It's not necessary to frame Mr. Williams' claim as requiring a positive obligation from the minister. The limitation on the type of data collected has resulted in a deprivation. The minister's decision not to collect race-based data infringes Mr. Williams' Section 7 negative right not to be deprived of life, liberty, and security of the person. Mr. Williams is not claiming that the minister owes him a new social benefit. The minister already collects COVID-19 data. Mr. Williams simply requests that he continue to do so, but to do so in a manner that does not infringe his Section 15 or Section 7 rights. Our claim here is analogous to the claim argued in Insight. There, rather than arguing that the minister owed the claimant a positive duty to provide safe injection sites, the claimant successfully argued that the minister's revocation of an exemption infringed their negative Section 7 rights. Justices, our
But the revocation of something is an act of government. The not collecting data is something that they're not doing, and you're saying that they should do. How is that not a positive, positive obligation that you're arguing for, and a positive constitutional obligation? It's different than insight.
Well, the distinction between positive and negative obligations is often artificial and unnecessary. For example, the right to vote, the right to trial by jury, they both impose positive obligations, but they're not framed as positive rights. They're negative rights. And Section 7 specifically, the door's been left open in Gosselin to the possibility of it having positive obligations. And on a few occasions, the court has actually imposed positive obligations under Section 7.
Again, I don't take issue with that. And in fact, I think that there is a basis to say that there can be constitutional obligations. But you're saying that this isn't a constitutional obligation you're arguing for, and I have difficulty with that. I don't have a problem saying theoretically, if the evidence supports it, there can be a constitutional obligation, but that's not what you're saying.
It's not necessary, because in the same sense as insight, we have a deprivation here. We have an infringement to the Section 7 rights to life, liberty, and security of the person, and those deprivations infringe negative rights. And for those reasons, it's not necessary to define this as a positive obligation.
So what would you say about the fact that you're citing paragraph 309 in Gosselin, which is actually Madame Arbour's dissent? How much weight can we give to that statement there from Gosselin in that context?
We cite the dissent in that context, because at some point the Supreme Court, as well as the Court of High Diversity, needs to extend positive obligations. That needs to happen. But for our case, at the moment, our case can be argued without imposing positive obligations on the minister.
Since Gosselin, maybe you can assist me, because I mean, Gosselin is a fascinating decision, especially the dissent, but has that notion ever been adopted by any case since that time? And this isn't a trick question, I'm just looking to see whether or not it has been.
Well, there's been two cases. New Brunswick versus GH. In that case, the court imposed a positive obligation on the to provide counsel in a child custody hearing. That's a positive obligation that's been imposed under Section 7. JG.
New Brunswick, yes. And JG. Okay.
That's correct. Yes, my mistake.
We're talking about the Robotham issue.
Correct. And then also, not directly, but also in Jane Doe versus Toronto Metropolitan Police. In that case, the court's decision implies that there's a positive obligation to warn when there's no knowledge of a risk or of a danger. And that's very similar to this case as well, because the minister is aware that there is disproportionate Black suffering. Under those circumstances, it is possible that the government has a positive obligation to step in here. Justices, Justice.
No, it's just you seem to have caved on it not being a constitutional obligation. Now you're saying it is a constitutional obligation, but it doesn't matter. Go ahead.
I'm going to take this opportunity then to go to the New Brunswick case and how the court there was applying it, because I'm having the same challenge here, which I think is the main challenge in this case. If you look at paragraph 113, one of the paragraphs that you cited in that case, it's referring to gender equality and single mothers being disproportionately and particularly affected by child protection proceedings. But again, this is a context of a state action, which is then creating a Section 7 or a Section 15 breach. Where is the governmental action that's creating the breach here that you're arguing?
Well, the starting point with the collection of COVID-19 data would need to be that the largest amount of data is the best practice. So at some point, the minister has decided to narrow that data set. And by narrowing that data set, that's the governmental action. The minister gets or they have a duty to collect data for health-related purposes, and that comes from the Department of Health Act. So in fulfilling their duties under that act, they must act constitutionally. So if the minister's decision has infringed on the charter rights of our clients, then there's an obligation that it needs to be subjected to charter scrutiny.
Okay, I think we might be getting somewhere here because this is a good thing. I was looking for some sort of statutory authority. So what is the name of that statute? The Department of Health Act?
Department of Health Act, section 4 sub 2H, I believe.
Okay, I'm going to look that up. Please proceed.
Justices, our submissions regarding section 7 can be found starting at paragraph 47. In the Supreme Court of Canada decision, Justice Martin correctly held that the failure to collect disaggregated race-based data engages the right to life because it subjects Mr. Williams to an increased risk of death. COVID-19 disproportionately kills Black people. Disaggregated race-based data is needed to address the disproportionate mortality rate. Therefore, the minister's refusal to collect that data subjects Mr. Williams to an increased risk of death.
Counsel, if we already know that Black Canadians are disproportionately dying from COVID-19, why do we need this extra layer of government data collection if it appears to be public knowledge already?
The little bit of data that we do have is coming out of the United States, and it's enough to let us know or give us an indication that there's a significant problem here, but it's not enough to develop a solution. So the data is needed in order to effectively respond on a national level. The race-based data coming out of the United States, it actually is indicating that the death rates within Black communities can be up to 6 times higher than that of white communities. And the data, the little bit that we have coming from Toronto indicates a similar pattern. The data is essential for understanding how and why racialized communities are disproportionately dying, and is also essential for developing life-saving measures tailored to the Black community. The minister's decision, by ignoring the disproportionate mortality rate, it's making it impossible to tailor a response aimed at saving Black lives.
Okay, so counsel, I'm following you now and I am intrigued, okay? The section here is section 4 sub 2 sub H, is that correct, that you're referring to?
I believe so, yes.
Okay, the challenge that I have here now, because I am trying to follow this line of thinking, is that this says subject to the Statistics Act. In other words, this obligation or duty that you're saying that the minister has to collect this information is still subject to the requirements of the Statistics Act, which is, as I understand it, operating on a census basis. It's doing things in a certain way. So how do you connect that obligation that's constrained by the Statistics Act and then apply it in this context of COVID-19?
So we accept that the minister's decision is a response to the urgency of the pandemic. And initially there'd be no faulting the minister's decision. But as soon as we start getting indications coming from the United States that there is a significant problem, that Black communities are experiencing mortality rates 6 times that of white communities, at that point, there's an obligation for the minister to start collecting the data so they can figure out what the problem is. By not doing that, the minister is allowing the Black community to continue to experience those disproportionate effects. So that's where the minister—
You would agree with me, though, if we're still using that statutory authority that you pointed out to me, that would have to be done under Statistics Canada then, right?
Well, it's subjected to Statistics Canada, that's correct. But the minister, at the end of the day, has the duty to collect health-based data. And in doing so, the collection of that data must be in line with the rights under the Charter. And in this case, it is infringed Section 7 and Section 15. The minister's one-size-fits-all data collection system is creating an increased risk of death to Mr. Williams and other Black Canadians, and that's engaging their Section 7 rights. The minister's decision also engages the right to liberty and security of the person. As is the case in Carter, it's appropriate here to consider liberty and security of the person together, because the minister's decision limits Mr. Williams' ability to make fundamentally important and personal medical decisions. Excuse me. Section 7's consistently been held—
Sorry. What evidence is there here that race-based data would have any impact on medical treatment choices?
Justice,
aside from your say-so and your argument, what's the evidence? Is there any?
We're in a bit of a catch-22 situation because we know that there's significant mortality rates or effect of COVID-19 that's been affecting the Black community. And we're saying we need the data to completely understand it. And that's what makes it difficult for us to tell you exactly what can be done. But I can offer a hypothetical. Some of the data community of the United States indicates that some communities are not responding as well to certain treatments. For instance, the use of ventilators. An alternative is the use of high flow nasal cannulas. In that situation, if we're able to establish from the data that part of the treatment could be adding to the disproportional effects, then we can actually use the data to respond effectively. But we're in the situation where we need to see the data to understand exactly what's happening.
But does the U.S. Experience indicate that race-based statistics it helps determine whether, for instance, ventilators will or won't be effective, or is that just, again, the possibility?
At the moment, we don't have the evidence to establish that definitively, but it does seem to indicate that, and there's a correlation.
Okay, so what I'm going to ask here then, I think it's still an extension of what you're proposing. If the government simultaneously with their failure, as you propose, to collect data, race-based data, uses targeted interventions, let's say with vaccines or other types of things for higher risk populations, just based on the data that is being collected, then you would agree that there isn't an adverse effect? Would that be, we have to have some sort of adverse effect. Where's the harm or the risk or the threat to life, liberty, the security of the person, or the differential treatment if the government is still able to target high risk populations without the collection of race-based data?
If that targeting was able to affect the disproportional mortality rate, then that would be an accurate response. But at the moment, the government is not doing that.
It's also still very early days, right? I think, we might be receiving those vaccines in September is what I'm hearing. So, it's still very speculative about any adverse impacts or adverse harm. And so it seems like this litigation might even be premature.
Well, what's known for sure at the moment is that there is disproportional effects and that Black people are disproportionately dying. Now, we can't be certain of exactly how that data can be used to solve the problem without physically seeing the data and seeing what it implies. But we're in that situation where we're reliant on seeing it to give you an exact response to that answer.
So, counsel, unless there's any objections from my fellow colleagues on the bench, you only have 5 minutes left. They might have missed the sign there. I think the Section 1 arguments are actually very important in this context. If there's any objections, maybe, unless there's any objections, Chief Justice, do you think maybe we can move there?
I leave it to the appellant, but I don't disagree.
Well, Justice, our full submissions concerning Section 1 can be found from paragraphs 70 to 80, in which we make 3 submissions in line with the test from Oakes. That the minister's decision is not rationally connected to the objective of preserving the health of Canadians, that the minister's decision is not minimally impairing of Mr. Williams' rights, and that the deleterious effects of the minister's decision outweigh their salutary effects. However, the heart of Oakes is the proportionality test, where the purpose is to balance individual rights against competing societal interests. In Mr. Williams' case, there's no balancing necessary because while collecting the race-based data upholds Mr. Williams' charter rights, it's also of great societal interest. Deprivations to Section 7 rights have never been saved by Section 1 because Section 7 rights are fundamental societal interests. Additionally, it's within society's best interest to ensure that all Canadians are to be treated as equally deserving of concern, respect, and consideration within the purposes of Section 15. The collection of disaggregated race-based data is in the best interest of all Canadians because having an accurate, more complete data set will give Canada a much greater understanding of COVID-19, allowing for the resources to be allocated to where they can be most effectively and efficiently used to respond to the pandemic. This is to the benefit of all Canadians. Mr. Williams' rights cannot be balanced against competing societal interests because they align with societal interests. The weights are all on the same side of the scale.
So, counsel, I'm going to try to get some questions in there before your time is done. The first part here, paragraph 72, where you're breaking this down, you say the deprivation of Section 7 is arbitrary, and you're citing Carter here, I believe the paragraph that you were citing is paragraph 119. And the difference here is that there's a blanket prohibition. There's the government saying you cannot do something. And that was done in an arbitrary manner. That's not what's happening here, right? The government is not prohibiting the collection of race-based data. If hospitals want to do it, if local communities want to do it and try to do that, they can do that. What you're saying is that they have an obligation to collect that, and that's arbitrary. Isn't that what you're saying?
Well, I would disagree with your framing of Carter. In Carter, it's a very similar situation. The court was asked the question whether or not it was legal, but also whether they had the duty to provide access to assistance in death. And in that case, the answer was yes. They did have to provide that assistance. So in the same thing here, we're looking at a case where Black people are disproportionately dying, and we're saying that the minister does have an obligation to provide that data, provide access to it. It's necessary for decisions of fundamental importance and of personal autonomy. To summarize, the minister's decision infringes Mr. Williams' equality rights by reinforcing racial health inequalities and by perpetuating systemic racism. It also allows the Black community to continue to experience disproportionate effects of COVID-19. In conclusion, this case is not just about Mr. Williams' rights. It's also about Canada taking its rightful place in the international community to stand up and declare that Black lives matter. This court is faced with a clear choice. It can allow the government to continue to hide systemic inequality, or they can work to expose it. For all the reasons put forth today, the appellant respectfully requests that the appeal from the Supreme Court of Canada be allowed and seeks the declaration that Mr. Williams' Section 7 and Section 15 rights have been infringed. The appellant also requests that the minister be required to collect COVID-19 data in a manner that does not infringe the Charter. Justice, if there are no further questions. Those are our submissions.
Respondent?
Thank you, Mr. Chief Justice. And with my thanks to the court and my learned friends, good evening, Your Honorable Justices. I'm Gregory Sanders, SANDERS, for the Respondent, Canada's Minister of Health. My co-counsel tonight is Aria Kamal, KAM-AM. Today I'll outline the orders we're seeking in this case and support the doctrinal arguments contained in the Respondent's Factum. I'll discuss the Appellant's Factum and arguments, and I'll suggest that, in light of the legal and logical errors in that Factum, the Supreme Court's ruling in favor of the Respondent ought to be upheld by this court. Finally, by way of conclusion, I'll introduce my co-counsel, who will consider the theoretical arguments at issue here. COVID-19 is a very serious threat to the health and well-being of Canadians. This is especially true for vulnerable Canadians, including those who are still negatively affected by the systemic racism that exists in Canada. Despite this, requiring that the minister adhere to a new positive obligation to collect disaggregated data is not the solution to either of these problems, COVID-19 or systemic racism. With that in mind, the government is seeking the orders contained in Part 5 of our Factum, which begins at paragraph 74. Specifically, this includes our request for an order upholding the Supreme Court's ruling in this case and dismissing this appeal. I will now turn to the doctrinal arguments of the Respondent's Factum, if it please the court. Thanks, sir. There are two doctrinal issues considered in the Respondent's Factum. The first is whether the minister's aggregation of race-based data pertaining to COVID-19 infringes the appellant's right to life, liberty, and security of the person protected by Section 7. The second is whether the minister's failure to categorize race-based data pertaining to COVID-19 infringes the appellant's right to equality protected in Section 15. Our first doctrinal argument, in response to the first issue, begins at paragraph 18 of our Factum, where we argue that the appellant's Section 7 charter rights have not been infringed. At paragraph 19, we outlined the test for a Section 7 infringement, and I won't go over that again unless that would be helpful. The government's position is that the appellant has simply failed to demonstrate an impairment of a Section 7 interest and corresponding right because there is no rational connection between the minister's acts or omissions and the threat that COVID-19 posed to the appellant's life, liberty, and security of the person. The respondent concedes that the appellant's life was threatened by COVID-19. However, it strenuously denies that the minister's data collection practices have any connection to the threat and harms of COVID-19. An infringement to one of the interests protected in Section 7 is a necessary precondition for finding a charter violation. The appellant notes at paragraph 52, referencing Carter in Canada, that the security of the person and liberty interests may be considered together, and I'll respect this as I now turn to those interests.
Well, the argument that I've been hearing from the appellant is more about in citing not only Carter, but also Eldridge and other cases based on the healthcare system. It's about an access to a system that is systematically exclusionary to Black Canadians. That's how I'm understanding it. And if there's a simple fix that can address that issue, and that simple fix arguably would give greater access and therefore save lives, why shouldn't we do that?
Thank you for the question, Mr. Justice. I think that the relevant or the related argument that they're making is about the nature of the data that's being collected in its disaggregated form, and their argument that it creates a one-size-fits-all approach. Am I sort of on the right track? So our argument is that, first of all, that the minister's data didn't collect or didn't create, extend, or offer any benefit. But I'd also like to turn to the appellant's argument, which starts at page 23. And so their critical argument for what
before you do that, I'm gonna forget my question otherwise. So before you get into that, you said that they're not offering any benefit. And so then what that brings to mind is obviously SHAOI, where if the government is going to provide, there's not an obligation to provide a healthcare system, but if we are going to provide a publicly funded healthcare system, it should be done in a constitutionally compliant manner. You would agree with that?
Yes, sir.
Okay, so the fact that we're providing a healthcare system which is invariably being used to treat a pandemic, a health-based issue, isn't there some room for constitutional analysis in the provision of those services?
Certainly.
Please proceed. I'm willing to hear the next part.
Sure, thank you. I appreciate that. So maybe I'll turn to the appellant's argument, if you don't mind. They're at paragraph 28, they say that the adverse distinction based on Mr. Williams' race arises due to the omission of disaggregated data, leading to the implementation of health measures being premised on data which ignores the unique experience of Black Canadians and the disadvantages they face through health inequities. They continue on in that paragraph. Accordingly, the minister's approach to the pandemic provides unequal benefit, concern, and consideration to the Black community by equating their experiences with that of their privileged white counterparts, unquote. Unfortunately, honorable justices, this cannot be reconciled with their claim, which we're going to accept as true in paragraph 16, which states that, quote, in Ontario, for every white individual who is infected or dies from due to COVID-19, there are 2 to 4 Black Ontarians who are infected or lose their life to COVID-19, unquote. Honorable justices, if there are 2 to 4 Black patients for every white patient that is infected or dies from COVID, and if that ratio holds true for data reported to the minister, who collects it in a disaggregated fashion, then how can the, quote, unique experience of Black Canadians and the disadvantage they face, unquote, be given unequal benefit, concern, and consideration, unquote? More simply, justices, if there are 2 to 4 Black patients to each white patient, the minister's disaggregated data would be a reflection more of the average Black patient's experience, overrepresented as they are in the data, than the average white patients who are underrepresented in the data.
I'm not sure I follow. You're saying that because there are more Black people suffering with COVID, that the statistics will somehow be more about Black patients or Black sufferers? I think that's just the raw numbers. I think that what the appellant is looking for is some more nuanced information, some more details that may explain why there is this disproportionate impact. That's my understanding. And if that's the case, how does what you say help?
Yeah, thank you for the question, Mr. Chief Justice. I think just to clarify, the argument that we're making is that the data is already a better reflection of Black COVID patients than it is of white COVID patients. And the result of that is that any healthcare policies premised on that data are, admittedly unknowingly, but are tailored to Black patients because the data that it's from is based more on Black patients than white patients.
But isn't that just a failure of our current healthcare system and our broader society at large? The fact that we have more Black patients disproportionately. I mean, this race-based data will help us move upstream, if you will. That's the argument, as I understand it, and engage in more preventative efforts that will reduce the number of Black people who are dying from COVID-19. Correct?
If I may make two qualifications, perhaps, to that statement. First of all, any benefit to be derived from the data is speculative at best. The appellant has provided sparse information by way of specifics about how this would help. The second consideration or second clarification that I would make is, I'm sorry, can you repeat the second half of your question? I just want to make sure I answer this correctly.
That's fine. You can move along.
Okay. I just one more clarification. This is the case at bar is the case of Mr. Williams. It is not the case of society at large. It is not the case of every Black or white COVID patient. This is a very, I urge the court to look at this as a very narrow question of law that relates to the appellant in this case, and not everybody else who could conceivably fall into the same category as him.
I had understood that the rules of engagement, so to speak, here were that we're not getting into standing, and that's really a standing issue. The complaint is the failure to gather statistics about race in relation to COVID generally. So it's not just about Mr. Williams. And what the argument you just made is effectively a standing argument, isn't it?
The argument that I'm making, sir, is that the facts before this court are related to Mr. Williams, and this court has the jurisdiction certainly to consider those facts in that argument, but I am here representing the government in that case. And so I'm not able to speak for the government on behalf of or to every COVID patient.
Well, I'm going to take it further then, because I think those questions become more relevant under Section 1, in particular when we're looking at proportionality, but also the rules of engagement, as my fellow justice said, are construed in such a way that theoretical issues can in fact speculate on, for example, whether or not the rights under Section 7 and Section 15 can be construed differently in light of the individualization or the collective nature of those types of rights. So in particular, as it relates to marginalized communities, that's an explicit possibility or issue before this particular court. So perhaps you want to address that as to perhaps why we should or should not approach these issues in that way.
Thank you for the question, Mr. Justice. I think perhaps the best way to do that is to make my Section 7 argument and see if that answers your question. Is that acceptable? Thank you, sir. The government's position, as I've said, is that the appellant has simply failed to demonstrate an impairment, which is the required first step for a Section 7 infringement of one of the interests covered by Section 7. So perhaps if I could, I'll speak briefly to the liberty and security of the person interests. And so the liberty interest, insofar as it pertains to imprisonment, is simply not applicable here. And it's the minister's position that the portion of the liberty interest concerning an individual's freedom to make personal choices is not triggered in this case either. The security of the person interest may be triggered when the state uses physical force against a person, or when the state's actions inflict severe psychological stress on the claimant. The triggering of these interests is considered more thoroughly at paragraphs 26 to 31 of our Factum, where we suggest that the key question is whether the life or security of the person interest has been threatened by the minister's data collection practices. This is not the same, honorable justices, as asking whether COVID threatened these interests. In response to this question, our position is that where the appellant's liberty and security interests were threatened, the threat was entirely owing to his COVID-19 diagnosis and illness, rather than to the type of data collected from other patients. And so in support of this, we argue that the appellant produced no evidence to demonstrate, for example, an increased burden accessing medical care, a lower standard of care, a longer or more painful recovery period, an inability to understand or make choices with respect to treatment, or any other limitation on the appellant's ability to make fundamentally important medical decisions, or any other type of decision, including informed consent to undergo medical procedures.
Counsel,
Counsel. Sorry.
I think you've conceded that COVID poses a threat to life and potential security of the person. If the government can take steps to mitigate that threat and to mitigate the threat to life and security of the person, isn't the government obligated to do so? And that can be on an individual basis. It can mean different things for different people. It can mean something different for a white Canadian or Indigenous Canadian or a Black Canadian. So in this circumstance, if there were steps through data collection that the government could take to mitigate the risk to Mr. Williams, why shouldn't they do so?
Thank you for the question, Madam Justice. My response to that would be in the form of perhaps a parallel situation. The government could take steps tomorrow to virtually eliminate poverty across Canada and relieve the suffering of people who are disproportionately affected by poverty. That doesn't mean that the government has a constitutional obligation to do that. It just means that it could. And I think that this situation is similar. And I think where my friends and I, where the widest gap is between us, is whether or not, even though this is something, whether or not the government has a constitutional obligation to do this. And our position is that they have provided no evidence of that legal question. Perhaps they've satisfied the moral question or the theoretical question, but this is a court of law, and our position is that they just haven't provided enough evidence to answer that narrow legal question. Does that answer your question, ma'am?
It does, but I think, isn't that taking an overly narrow view of Section 7 and, more broadly a narrow view of charter rights? Not every case will have a previous case saying the exact same thing that you want it to say. So given, that we consider ourselves a progressive society and working towards the advancement of marginalized groups, wouldn't a broader interpretation of Section 7 obligations be appropriate here?
Perhaps, but our concern, and I think that this was just echoed by Justice Brown, is that when you open the door to those sort of positive obligations, I mean, in this specific example, how far does that go? I mean, I don't think that financial consideration should be chief in a question or in a situation where people are dying, but they ought to be a consideration. And so I think that one of our concerns is that once you open the door to this, it's hard to tell how far this goes.
But maybe we should be opening that door, right? I mean, we're spending millions on vaccines, on PPEs, and all kinds of things. And there's never more of an important time to think about rights to life, which is one of those components there in Section 7, than during a worldwide pandemic. Wouldn't you agree?
Yeah, yes, sir, I would. I would perhaps echo one of the criticisms that I believe you made of the appellant's submission, which is that they failed to provide evidence of how the solutions that they're seeking would solve those problems. That very specific direct examples we contend are missing here. And
I'm sorry, go ahead. Finish your thought.
Thank you, sir. Thank you, sir. And so given that this case contemplates maybe not a novel, but certainly an unusual solution in the creation of a positive obligation, there ought to be very clear and compelling evidence why that solution is appropriate.
So,
thank you, sir.
If I may, in answer to my sister's question, you said, well, what about, we don't have an obligation to deal with all poverty issues. Is that response not inconsistent with the response you gave to my brother Justice's earlier question, where he said, although there may not be a constitutional obligation to provide funded health care, where the government has undertaken to do so and has set up a system to do so, then they have an obligation to do so in a constitutional manner. You conceded that. So doesn't that make this different than the poverty situation? The government has not undertaken well, there may be some arguments that they have, but they haven't undertaken to create a statutory system to prevent all poverty. They have undertaken to create a universal healthcare system. Is that not different?
I don't know that specific question. Maybe I could offer more in the way of a comment. The choice by the government to offer healthcare to everyone is one that, in Eldridge, for example, should be, the government should be held to provide the same benefits that it provides to some people to everyone else. However, that's not the issue here, Mr. Chief Justice. The issue is whether or not there is a benefit or some burden or some combination contained in the minister's disaggregated data or created or extended by her data collection practices. And our position is that there is no burden, there is no benefit. And so those may be different questions, Mr. Chief Justice. Does that answer your question, sir? Oh, sorry. Sorry, you're muted.
Sorry, good. Just go ahead.
No, I was just, okay.
While you're making your notes, I might ask a question. So would you agree with me that the charter, one of the main roles of the charter is also to protect, let's say, vulnerable groups and minority interests? It's raised in many cases as, for example, the tyranny of the majority.
Yes, sir.
And so isn't there room here for some reinterpretation of charter provisions in ways that perhaps we haven't considered that take into special consideration some of these minority concerns?
I think, thank you for the question, sir. I think that there's always room, or there always should be a consideration of minority concerns. But I think that that consideration, and in this case, the solutions offered by the appellant, that consideration should consider whether those solutions are legally appropriate to begin with, but also whether or not they actually address, and it's clear how they'll address the problems which they purport to solve. And our position is that the appellant has not provided sufficient specific evidence of how that would happen.
Well, if I understood their submissions, they said that's putting too much of an onus on a vulnerable and marginalized community to begin with, as in you won't have that answer until you actually start collecting that information. So what's the harm in collecting that information? And also they said, especially in their Section 1 arguments, everybody in society will benefit from the collection of that information.
Yeah, thank you for the question, sir. I think that once again, I would echo Justice Brown, who talked about, for instance, privacy concerns with collecting this sort of information. I mean, lists of people's skin color has certainly been used historically in not very nice ways. And so I know that my co-counsel is going to address this further in her argument. And so with your permission, perhaps I'll leave that to her. Did that answer your question? So maybe if I will, I'm cognizant that time is running out. Maybe if I will, I'll just very briefly discuss my Section 15 argument. So I won't go over the test, but suffice to say, the government's argument is that the first component of the test, receipt of differential treatment, has not been satisfied by the appellant, who neither provided evidence nor suggested an increased burden to accessing healthcare or to receiving the same quality care available to others. Likewise, the appellant offered no evidence that he faced discriminatory treatment during the triage, diagnostic, therapeutic, or recovery phases of his care. Indeed, at the time of his illness, there were very few proven therapies, and certainly no vaccines available to anyone from which a patient might be excluded, discriminatorily or otherwise. And so if not in the treatment and recovery phases, then, Honorable Justices, perhaps there was discrimination in the diagnostic stage. I respectfully submit to your honors that there is little or no opportunity for discriminatory treatment here, and indeed, none has even been alleged by the appellant. Even so, a brief discussion is perhaps warranted. Diagnostic services available for diagnosing COVID infections consisted then, as now, mainly of two types of tests: a molecular or PCR test, and antigen testing. And so while it's theoretically possible that a physician could fail to prescribe or provide a COVID test, the appellant has provided no evidence or even an allegation of this type of burden. The only other possible step along the diagnostic process vulnerable to discriminatory action is the failure of lab technicians to properly process and interpret the results of a COVID test. And so while this is possible, it's not plausible. By the time the typical test arrives at a lab, which may not even be in the same building as the patient, it is simply tissue on a nose swab. How could one positively determine the subject's skin color and act discriminatorily as a result from what is tissue on essentially a Q-tip? And so as such, I respectfully submit to the court that the appellant has failed to demonstrate discrimination accessing healthcare. And in failing to demonstrate their satisfaction of the first part of the test laid out in Andrews, they fail the whole test. The burden is on the claimant here. And I would also remind this honorable court that it's an enhanced burden because this is a case of adverse discrimination. And so I think maybe, given that there's some time left, I'll turn very briefly back to my argument, which I made initially concerning the 2 to 4 Black patients for each white patient and the, what must be the overrepresentation of Black patients in the COVID data. And so I think that if anything, this demonstrates that Black Ontarians, who the appellant says are far more likely to be infected and die from COVID, still suffer from racism and housing, employment, and other types of discrimination. Importantly, that racism and discrimination leads to demographic and social conditions for vulnerable people in Canada that encourage the spread of COVID-19. This is a sad state of affairs for a supposedly multicultural state like Canada to be in. However, Mr. Chief Justice, it is not indicative of the government's so-called unequal concern for non-white patients. Rather, if anything, it shows that owing to grassroots racism, Black patients are more likely to suffer from COVID and are thus more likely to be overrepresented in the disaggregated data. As such, there can be no infringement of Mr. Williams' Section 15 right, as the data provides no benefit to white patients and no corresponding burden to Black ones. I've argued that the appellant's factum shows that the disaggregated data is more reflective of Black patients and is therefore more likely to result in the creation of healthcare policies that are unknowingly tailored to Black patients. And so thus, while there's likely no benefit to the minority of white patients in the data, there may actually be a benefit for Black patients.
So, counsel, I just want to make sure I'm understanding the argument. What you're really suggesting is that there's a possibility, and maybe just answer this question because your time is up, there's a possibility that right now we're inadvertently developing policies that benefit Black Canadians because of the disproportionate number of Black Canadians that have COVID. Is that your argument?
That's correct, sir. Did you want me to expand on that, or was it just a?
I'll leave it to my fellow justices if they're intrigued enough.
No, I've heard it, and it was already adverted to before, and time is up. So unless my sister has any questions, I think we should move on.
With my thanks to the court. Oh.
Thank you, counsel. Good evening, your honorable justices. As my co-counsel has mentioned, the respondent submits that the Supreme Court of Canada's decision in the Queen against Williams ought to be upheld. The reality is that COVID-19 itself does not discriminate against race, gender, sex, or age, and the implications of race-based data collection are far more insidious and dangerous than we are led to believe. In deciding whether or not this court shall overturn the Williams decision, we must employ an anti-essentialist lens, meaning that we must not attribute fixed patterns and defining characteristics to racial identities. While the lived experiences of racialized citizens must be acknowledged, we must also exercise due diligence to avoid the imposition of undue hardships on the very same groups of individuals we endeavor to protect. The notion that race-based data collection will inevitably lead to better policymaking decisions is a significant myth. It is the position of the respondent that a positive obligation on the minister to collect disaggregated race-based data will only work to dismantle the imperative aim of critical race theorist efforts to curtail racial essentialism within our contemporary society. A decision of this sort will undoubtedly create new opportunities to perpetuate negative stereotypes of race within our collective.
I'm sorry, counsel, you're gonna have to repeat that sentence for me about, just repeat that last sentence for me again slowly, please.
Absolutely. A decision of this sort will undoubtedly lead to new opportunities to perpetuate negative stereotypes of race within our collective conscience.
Maybe one more before that.
Oh, absolutely. It is the position of the respondent that a positive obligation on the minister to collect disaggregated race-based data will only work to dismantle the imperative aim of critical race theorists' efforts to curtail racial essentialism within our contemporary society.
So and that was the one which had me confused. You're gonna have to move a little bit slower for me, sorry, because I'm dwelling on every word. So you're saying that we shouldn't be trying to incorporate critical race theory into our society and our analysis. Is that your argument?
No, Your Honorable Justice. Respectfully, I'm saying that we should work to not inadvertently dismantle the imperative aim of critical race theorists' efforts to eliminate racial essentialism within our contemporary society.
And so how does this proposal to collect race-based data do that? I think that's where I'm losing you.
Absolutely, Your Honorable Justice. And if the court will allow me to do so, within my submission, I do unpack this notion a little bit further, and it will provide further context within this.
Perhaps slowly, because I need to follow along.
Absolutely, Your Honorable Justice. I will continue with my submission. To unpack this notion further, I will first articulate the indispensable lessons that we have learned from our society's historical embrace of pseudoscientific racial theories and their detrimental impact within our healthcare systems. Next, I will assert that a positive obligation on the minister to collect disaggregated race-based data will only result in further discrimination against racialized citizens. Finally, I will argue that good faith efforts to collect race-based data may lead to exacerbated hardships, increased surveillance, and increasingly insidious regulation of racialized communities.
Okay, now I follow it because I did read your factum, so I've connected the two. Thank you.
Thank you, Honorable Justice. I will now begin with the respondent's first theory argument. At paragraph 18 of the appellant's factum, it is stated that, quote, the fear and speculation of disaggregated data being misappropriated for a damaging outcome cannot and should not be used to justify the status quo, end quote. Respectfully, Your Honorable Justices, the fears that my friend is alluding to in this statement are not merely speculative, but in fact are coupled with disparaging realities that are rooted within our society's historical embrace of medical racism and pseudoscientific racial theories.
So if I may, what you're basically saying is we don't want to have this information because if you have this information, it could be misused, right?
Yes, Your Honorable Justice.
Okay, well, is that a reason to remain ignorant, to not gather information because if you have information, it could be misused? Or should the focus be to, once the information is gathered, make sure that steps are taken to ensure that there isn't a misuse?
Thank you for your question, Your Honorable Justice. And again, I will be unpacking this notion a little bit further, but my main point at this time is to emphasize to the court that there exists a grave risk in associating race-based data collection and race-based data itself within medical conditions and treatment. And I will provide the court with specific examples of this if you allow me to do so, Your Honorable Justice.
Well, before going on to those examples, I mean, the risk for abuse is there, of course, but would you not agree that the safety net, if you will, or the vanguard against abuses is the judiciary?
Yes, the judiciary.
So it's important that these issues become justiciable, that the court has oversight of the political decisions, if you will, that this government is making, and that the charter implicated, I guess, consequences be very much before the court in this particular case. I mean, if you're saying, as your submissions suggest, that we shouldn't have any involvement in this at all, then that doesn't allow us to play that role in ensuring that this information isn't misused.
Thank you for your question, Your Honorable Justice. Respectfully, I am not saying that we should not look at it at all. I am just emphasizing that there exists a grave risk in associating race-based data with medical treatments and conditions. And this is something that I think we cannot ignore. And I will be unpacking this, as I did mention before, a little bit further within my submissions, if that is all right. If it is all right to do so, I may proceed with my argument. So, as I mentioned, a couple times now, there exists a grave risk in associating race-based data with medical conditions and treatment. Race-based data collection has a fatal history within our nation, and as articulated at paragraph 19 of the Appellants Factum, public opinion is indeed difficult to change. Now, within our nation's history, negative social constructions of race justified medical social engineering efforts that were rooted in social Darwinism and concepts of survival of the fittest. In accordance with this concept, certain racial characteristics were attributed as inherently inferior and therefore detrimental to the advancement of the human race. This concept permeated dominant social perceptions at the time, and this perception was a primary tool that was used to regulate the reproductive abilities of those who were deemed to be detrimental to the advancement of the human race. Now, with the introduction of the eugenics movement in Canada, health officials enacted social engineering mechanisms within legislation in attempts to control the increasing population with forced medical sterilizations. And as a result of their collective inability to assimilate within normalized Eurocentric gender norms, Indigenous women were labeled as quote unquote feeble-minded, and thus they became a primary target of these forced sterilizations.
Well, counsel, I would be very, very concerned if this application had been advanced with that type of narrative. But in fact, it's very much the opposite narrative that we've heard in our submissions, which is that it's not the inherent race that is giving rise to susceptibilities, it is systemic discrimination and the other issues around race that very much gives rise to comorbidities that makes people more susceptible to the effects of COVID-19. So again, I mean, this is a very, very, very different approach. It's not paternalistic. It's not society saying minority, this is what you need and imposing laws. It's the opposite. These are minority populations saying this is what we need from the government in order for us to be protected. That's a very different argument.
Yes, Your Honorable Justice. But I would like to reemphasize that my particular argument does have a few different layers to it. And at this stage, it's important to understand how negative social perceptions can back up this idea that if individuals are more susceptible to carrying the virus, how that could actually work to their detriment on a societal level. I'm talking on a very macro level, Your Honorable Justice.
Is your approach to this issue not inconsistent with your colleagues? He said at least 4 times by my count, this is speculative. There's not sufficient evidence to show that the provision of race-based data is necessary, would be helpful. It's speculative. And now you're saying, well, if you forget this data, it could be used in a negative way. Is that not speculative? What's the evidence to support that just because there have been incidents in the past that this kind of data is likely to be so used? Again, we have models in the United States where race-based data is collected. Is there any evidence that it's been used in this fashion?
Thank you for your question, Your Honorable Justice. And to answer that point, I would like to emphasize that it is imperative that we consider the harms associated with race-based data collection within our historical context of our nation's misuse of it, especially within our healthcare systems. Respectfully, we do not have any existing proof that race-based data collection will advantage racial groups per se, but we have ample examples embedded within our nation's history of why intertwining race and racial data within medicine and the broader healthcare system can produce harmful impacts on racialized groups in Canada. And alluding to my example, forced medical sterilizations under the Alberta Sexual Sterilizations Act of 1937 constitutes as tangible reminders of the consequences of using race-based data to justify medical treatments and procedures, particularly when detrimental social constructions of race are involved. Therefore, it is the position of the respondent that it is better to err on the side of caution when deliberating incorporating the impacts of race-based data collection on the consequences of the pandemic. That is simply the point that we are trying to make, Your Honorable Justice, at this point. And if there is no objection, I will now transition into the respondent's secondary argument. Now, as my co-counsel has confirmed, current COVID-19 testing and treatment procedures produce no differential treatment upon racialized citizens who are seeking medical care. Free testing centers are widely dispersed throughout our municipalities, and treatments for the virus are available at many medical clinics or hospitals within our towns and cities as well. Therefore, our current testing and treatment procedures are not discriminatory in nature and do not produce differential treatment, as these resources are reasonably available to anyone who may need them. If, however, disaggregated race-based data is collected to prove social perceptions that racialized citizens are indeed more likely to become infected with the virus, this may then produce forms of differential treatment, as racialized citizens will then be identified as primary perpetuators of the virus. And an example of this can be found in the early days of COVID-19's emergence. Racially essentialist perceptions of Asian populations arose as these individuals experienced substantial amounts of racism and racial discrimination since the virus's first outbreak in Wuhan, China. And the significance of this is that as a result, COVID-19 became socially dubbed as the Chinese virus, and Asian populations were characterized as primary perpetuators of the illness. Now, in Toronto alone, yes, Your Honor.
If at that time, race-based data had been collected, wouldn't have been possible to prove through that data that Asian Canadians were not disproportionately carrying COVID? Could that not have actually helped resolve that dilemma or change that public perception?
Thank you for your question, Your Honorable Justice. The concern that we do have, and the point that I am trying to make with the collection of race-based data, is that race-based data, as I believe we have all heard tonight, will affirm this understanding that racialized groups are indeed more susceptible to contracting COVID-19 or being carriers of the illness. And so therefore, when you use empirical data to back up this notion, it becomes very racially essentialist in a sense where the general public, we must not forget that we're talking about society on a grander scale here, the general public will learn or have this idea that these individuals are now the primary perpetuators of the illness. And empirical data like race-based data collections do back that up. It will only solidify that reasoning, and which will lead, as my submission will entail a little bit further, which will lead to further marginalization and discrimination from the general masses. And I will unpack this a little bit further. Now, in Toronto alone, this sort of racial essentialism led to Asian businesses dropping more than 30% in revenue since COVID's initial emergence, as many Asian businesses and companies suffered great economic losses in Toronto's Chinatown district as a result of social marginalization and xenophobia from the masses. Further, COVID-19's association with the Asian population advanced anti-immigrant rhetoric, particularly towards Chinese immigrants within North America. Now, these realities have perpetuated stigmatized anxiety, resentment, and fear towards racialized groups who have now personified the virus. And I would like to remind your honorable justices that the COVID-19 pandemic is not the first time that racialized groups have been perceived by others as primary perpetuators of illness within the Canadian context. In 2003, the SARS outbreak hit Asian-run businesses so hard as people kept their distance from them based on this xenophobic reasoning that the Prime Minister at the time, Jean Chrétien, actually visited a restaurant located in Toronto's Chinatown district at the height of the crisis to prove that there was no need for panic. But this time around, however, uncensored hate speech is transmitted a lot easier through social media platforms, thus inviting wider audiences to embrace the same xenophobic rhetoric.
So can we address a lot of these issues though, and these concerns? I mean, I think we've all read your Factum too. So I mean, a lot of the arguments there, we've read them. We can address a lot of this simply by making this race-based data collection voluntary on behalf of the participants, which I anticipate is what would happen anyways, right? In other words, people self-identify what their own racial identity is going to be, and they would report that to the healthcare practitioners. And so on that basis alone, it's not the government, I mean, they're required to request or inquire and collect that information, but the participation is always voluntary. And so that, I think, distinguishes enormously from what you're suggesting here are the worst of the ills or the harms that could potentially emerge from this. Wouldn't that be the case?
You could definitely make that argument, Your Honorable Justice. However, I do think that it's important not to underestimate the implications of my argument here, because our main concern is that while it may be voluntarily collected per se, there still exists this reality of the empirical data being used to back up this understanding that racialized citizens are more likely to carry the virus and therefore are primary perpetuators of the virus, which really does only result in social isolation and marginalization from the rest of the masses. And as we've seen with the way that Asian Canadians have been treated after this understanding has permeated our social understandings, it's very evident, Your Honorable Justices, that this risk is not merely speculative, although it may seem so. It's actually grounded in realities that individuals are experiencing as a result. And further, as I've established that it does lead to further marginalization and discrimination, or at least runs the risk of doing so, I will now outline the respondent's third and final argument. The appellants, at their paragraph 14, state that, quote, race-based data has the ability to remedy existing systemic issues facing Black Canadians, end quote. I urge this court to be cautious in accepting this line of reasoning. Your Honorable Justices, no one can guarantee with utmost certainty that there's any benefit at all to be derived from race-based data collection in regards to the pandemic. Indeed, the appellants have not provided specific examples to counter this, and any existing theoretical benefits suggested by my friend are merely speculative. The reality is that past race-based data collection has not led to any meaningful policymaking within our nation's history. In the Canadian context, we have witnessed many race-based research projects on HIV and AIDS transmissions within African, Caribbean, and Black communities. This data, however, has not produced any tangible and effective solutions in alleviating the health prospects of individuals within these communities, as they continue to be disproportionately affected by HIV and AIDS in Canada. According to the Ontario HIV Treatment Network, although African, Caribbean, and Black communities make up less than 5% of Ontario's population, they continue to account for 25% of all new HIV diagnoses as of 2015. Therefore, the evidence continues to demonstrate that race-based data collection will not lead to better policymaking decisions nor alleviate existing racial tensions. I would also like to remind your Honorable Justices that race-based data can be misused across varying platforms to harm racialized citizens and communities for generations to come. And just one moment, okay. Well, while the appellant argues at paragraph 20 of their factum that, quote, the government will have the responsibility to ensure that disaggregated data will be used correctly and protected with privacy measures, end quote, I respectfully submit that this contention is inherently unrealistic. An example of this is the ongoing Russian hack of US government networks in what is most likely the largest cyber hack against the US in history. The most advanced encryption algorithms and privacy software failed to protect sensitive data from this operation, which ran unnoticed for 9 months. Further, the 2017 Equifax data breach compromised the financial information of 147.9 million Americans and 19,000 Canadians, despite the company's stringent security measures and software. While these breaches led to identity theft and stolen financial information from citizens, imagine the irreparable damage that this could have done if the information comprised of was race-based data. For these reasons, Your Honorable Justices, the respondent submits that the Supreme Court of Canada's decision in the Queen against Williams does not infringe the appellant's Section 7 and 15 rights. And indeed, the imposition of a positive obligation on the minister to collect disaggregated race-based data will only derail the imperative aim of critical race theorist efforts to curtail racism within our society. Subject to any further questions, Your Honorable Justices, these are the submissions of the respondent. Thank you.
Okay, any questions? I assume there's a brief reply.
Yes, we may exercise our reply.
See?
Our friends have mentioned that no meaningful data has been used, race-based data, to alleviate any health concerns. And we submit that that is a mistake of fact. In Ontario, we have already seen this, and Cancer Care Ontario has used race-based data to show that Black women were not being screened for cancers. And after they were doing this, they were able to deploy evidence-based strategies to decrease disparities by 28%. And the CDC has also illuminated that documentation of HIV rates amongst Black individuals and Hispanics has helped stimulate the programs of development programs that have decreased HIV transmission disparities by 25%. So our reply, and is our submission, that it is patently incorrect to say that no meaningful race-based data has been used.